was an interesting decision there last week in the High Court, and it's to do with this whole question of personal injury actions, personal injury claims, and solicitors referring clients to medical professionals. The background to the case is that in 2017, one of the judges there in the High Court, Mr. Justice Anthony Barr, described medical referrals made by solicitors as inappropriate. A plaintiff's GP should decide when and to what specialist a patient should be referred. Mr. Justice Michael Toomey then in December echoed Mr. Justice Barr's remarks in ruling on a case he said illustrates that this inappropriate practice has not come to an end. So this is the practice of solicitors referring clients to medical professionals. He stated, Mr. Justice Michael Toomey stated that a solicitor should not suggest to a plaintiff that he can refer her to a consultant or range of consultants chosen for legal reasons to support the claim for damages. This is because there's no medical basis for such referrals. Last week, however, Mr. Justice Keane Ferreter said that this view goes too far. A solicitor is entitled to advise a plaintiff to engage the services of a medical expert, and adding that a solicitor with experience in personal injuries litigation will typically be in a position to recommend suitably qualified and experienced medical experts. In his ruling published this week, and this is the case that is interesting, Mr. Justice O'Connor said that there was no challenge to the credibility, competence or impartiality of the medical witness to whom plaintiff Susan Healy was referred as part of her personal injuries claim against the HSE. The judge was assessing damages to be awarded to Miss Healy from Limerick City for a slip and fall in the shredding room of St. Joseph's Hospital in Limerick on November 7, 2013. The HSE had asked the court to determine whether Miss Leahy's injuries are partly or entirely attributable to a 2013 road traffic collision, for which she issued separate High Court proceedings which settled for €10,000 plus her legal costs. It also asked whether the injuries were caused by degenerative changes to her spine. So the HSE were asking these questions in the light of an assessment to be made by the High Court. The HSE further questioned the weight to be given to the evidence of the medical practitioner to whom Miss Healy's solicitor had referred her. So here's the question about the solicitor referring a client to a medical professional and whether it's appropriate or inappropriate. It is a matter for each judge to determine the weight to attach to evidence from a medic to whom a personal injuries claimant has been referred by their solicitor, the judge has found. So Mr. Justice Tony O'Connor, in a recently published judgment, said witnesses colloquially called guns for hire can be exposed through cross-examination or questions from a judge. There is currently no rule preventing a solicitor for any party from referring a claimant in a personal injuries action to a medical practitioner, although such referrals may interrupt the normal communications flow within the medical profession. So that is the latest position there. This judge, Mr. Justice Tony O'Connor, says that there's no difficulty and nothing inappropriate about a solicitor referring a client to a medical professional for examination, etc., because the evidence given by that medical professional can be exposed through cross-examination or questions from a judge. Hope you find this video useful. I'd appreciate if you gave it the thumbs up down below. Thanks a lot.